Assalamualaikum and hi, this is Business Bebas Talk Show. I'm your host for today, Nuraili Muhammad Noor. For today's topic, we are going to talk about the constitution of the company. What is constitution of the company? The constitution of the company is an agreement between the company and its members that consists of memorandum and articles of association. Memorandum of association contains the power and objects of the company, while the article contains the information about the rules and management of the company. So today we have invited two great panelists to discuss together about this topic. Please introduce yourself.
Hi, I am Miss Sabila and I'm currently working as a business advisor.
Hello, I'm Miss Dalina. I'm working as the lawyer for Wafi.
Therefore, last week we have opened an opportunity to other business company to share with us about their problem related to the constitution of the company. So, Success Serenjang Berhad has come to us and told us about their problem. We have met and interviewed the involved parties to get more information about this. In order to help them, we are going to give advice about their chances of success related to their problem. So we are going to hear the first problem through the interview video together.
Hi, Assalamualaikum warahmatullahi wabarakatuh. I am Mr. Wafi and I am also one of the executive at Bank2U Bank. So actually, Bank2U Bank is one of the lessor of the premises for Success Sendirian Berhad. Apparently, in Article 41 of the Constitution of Success Sendirian Berhad had stated that a lessor for the premises of the company has right to appoint new directors for the company. Due to this, Bank2U Bank as a lessor of Success Sendirian Berhad had decided to nominate me as one of the new directors for Success Sendirian Berhad. However, this appointment made by Bank2U Bank was disapproved and disagreed by the directors from Success Sendirian Berhad. I am very disappointed by this because the appointment made by Bank2U Bank was just based on the article from the Constitution. So my company, Bank2U Bank, and me wants Success Sendirian Berhad to accept this appointment because we believe that we already followed what is given based on Article 41 in the company's constitution.
Thank you, Mr. Wafi. So we have heard the first problem from Mr. Wafi himself. The issue stated here whether the Bank2U Bank has the right to appoint one of its executive, which is Mr. Wafi, as a director of Success Sendirian Berhad. Miss Delina, can you tell us more about this?
Based on Section 33, subsection 1 of the Companies Act 2016, the constitution of a company serves as a contract between the company and its members. There are mainly four effects of a binding contract, which is the effect of a binding contract between members qua members, effect of binding contract between members inter se, the effect of binding contract between the company and its directors, and the effect of binding contract between the member of the companies and also the directors of the companies. However, the constitution of a company does not constitute a contract between the company and outsiders. Therefore, outsiders has no right against the company. Even if the company give rights to the outsider has no right to comply with the company. Besides, if the company breach contract between the company and the outsider has no right to sue the company for breach of contract, nor take legal action against the company. Let's refer to the case of Raffles Hotel and Malayan Banking Berhad. MBB was the lessor of the land where Raffles Hotel was situated. The company was the lessee of the land. It stated that the company's article that the lessor has the power to appoint a director of the company. Based on the power given, MBB came up and appointed itself as a director. However, the company disagreed with the appointment and claimed that it was invalid. The High Court and the Federal Court held that the articles could not constitute a contract between the company and outsider. Since MBB was an outsider and also not a member, the article was invalid and MBB still has no right to appoint a new director of the company. In this situation, Article 41 stated that the lessor of the land of the company Success in Jengka has the right to appoint a director of the company. However, Bank2U Bank is a lessor, but it is also an outsider. Even if Bank2U Bank appoints Mr. Wafi, who is one of the executive as director of Success in Jengka, the appointment is still invalid. This is because an outsider is not a member of the company. Therefore, a person who is not a member cannot force the company to comply with the constitution. They also cannot prevent the company from altering the constitution even when the effect of alteration will result in a breach of contract. Success in Jengka also disagrees with the appointment and wishes to challenge its validity. It is because outsider has no right to appoint a director since the articles could not constitute a contract between the company and outsider. This situation is similar with the case of Raffles Hotel Limited and Malayan Banking Berhad.
Thank you, Ms. Delina, for your explanation. So, in this situation, we can conclude that even the company confers a benefit to an outsider, the outsider still has no right to comply the company with the constitution. In this situation, Bank2U Bank wants to appoint Mr. Wafi as a director, but the appointment was invalid since the article constitutes a contract between the company and the outsider. But if the company agreed to include a contract with a third party, regarding this matter, a breach of contract can occur. So, what the next problem happened in the succession Jengka between the succession Jengka and its members? Let me hear out.
My name is Cik Wizni. There has been a dispute or misunderstanding between me and the company Success in Jengka. Instead of speaking to me first and referring to the arbitration, they decided to bring this matter straight to the court. For your information, Article 44 of the Articles of Association has stated that any dispute among the company and its members must be referred to the arbitration. So, this is why I am so dissatisfied with Success in Jengka. They could have referred to arbitration, but why did they have to bring this matter to court?
So, that is the problem happened between Cik Wizni and Succession Jengka. The issue stated here whether Succession Jengka can take action as to dispute against Cik Wizni. We move to our next panel, Ms. Sabila, to explain and advise about this problem.
Bismillahirrahmanirrahim. Thank you to the MC. So let us begin with the law that can be applied in this case. The first law would be Section 32 of the Companies Act 2016. This section explains that the constitution of a company has the effect of a binding contract between the company, its directors, and its members. So it can be easily concluded that the constitution is also like an agreement. The second law that can be applied in this case is Section 33 of the Companies Act 2016. In this section, it further explains about the Constitution. The Constitution is said to serve as a contract in between the company and its members. The Constitution binds the company and its members to the extent as if the Constitution has been signed or sealed by each of the members. Therefore, any failure to observe the provision in the Constitution will result to a breach of contract. Based on this section, it allows a company to take legal action against its members in order to make sure that they comply with the company's constitution. If any of the members is unwilling to comply, the company may force them to do so. In the case where the company is unable to observe the constitution properly, hence the other members may force the unwilling members to comply by suing them personally using his own name. Therefore, it can be easily understood that both parties can sue and be sued for any breach of any provision in the Constitution. The proper plaintiff rule stated that a member is not to take a legal action against the company if the injury complained of is the company itself. Therefore, a member may only sue the company if the non-compliance of the Constitution complaint is related to their personal rights as a members, for example, their voting rights. This simply means that the members can only sue personally using his own name but not of the company's. An article of association of a company, AOA, may provide that any dispute should be referred to arbitration. What is arbitration? Arbitration is a form of dispute settlement where both parties can avoid resolving their dispute in the court. In the case where this provision exists in the constitution of a company, any dispute that arises between the company and its members shall be resolved by themselves, and both parties are not allowed to bring this matter to the court. This matter is explained further in Hickman and Kent case where a dispute had arises between the company and its members, namely Hickman. Hickman had brought an action to the court complaining that there is some irregularities in the companies. However, the company defended itself by relying on the AOA of the company to prevent Hickman's action. The article of association of the company provides that any dispute that arises between itself and its members shall be referred to arbitration. Hence, in the end, Hickman was bound by the AOA. Moving on to the application of law in this case. As we all know, Cik Wisni is one of the members of Success Sendirian Berhad. Due to unknown reason, a dispute had arises between them both that had drove the company to take legal actions against Cik Wisni. However, this action made by the company is dissatisfied by Cik Wisni and she decided to defend herself. Article 44 of AOA of the company had provided that any dispute that arises between the company and its members shall be referred to arbitration. However, since Success Sendirian Berhad had brought this matter to the court, this action made by them is considered void. Cik Wisni is not bound by the legal action taken against her. However, the company is bounded by the AOA. This is because the AOA of the company had already clearly stated that any dispute shall be resolved by themselves. However, the company brought this matter to the court. It is a proof that the company failed to observe the constitution properly, hence resulting to a breach of contract. This case is similar to Hickman and Kent case.
Thank you, Mrs. Sabila. In conclusion, according to Article 44 of the Constitution of Company Success Sendirian Berhad, state that any dispute happen between the company and its members shall be referred to the arbitration should be followed by the company. All in all, Success Sendirian Berhad cannot bring the matter to the court for settlement. Instead, should be referred to the arbitration. So for today's topic, we have covered and discussed about the problem happened in Success Sendirian Berhad. I hope all the parties involved can understand and apply the law in their current situation. We have come to the end of the show. I'm Nuraili with me. We will meet again with a different topic next week. See you again in Business Bebas Talk Show. Bye bye.
Bye bye. Thanks for watching.